the target company level, and we are looking at the holding at holdco level, we are actually overlooking the holding in target company at all. For instance, supposing the capital of this company is say rupees 100 crores, let's say it's 100 crores here, and let's say the capital of this company is only 5 crores. So I would say what I'm holding 20% of 100 crores. My holding itself is 20% of 100 crores is 20 crores, which is more than the capital of the target company itself. Numerically, the working doesn't make sense unless we bring the holding down to the target company level. And the support to this view comes from the word ultimate beneficial holding in the beginning part of definition of clause 2(1)(e) of the SBO rules. We say within holding ultimate beneficial ownership of 10%. So ultimately we have to see whether there is a 10% holding or not. That numerically makes more sense. Though going by language of Roman 1, 2 and 4, one might be tempted to believe that the holding is to be computed at the holding company's level, though to my mind that's not very in context of computation of SBOs, that doesn't help us in the context of SBO computation. So that's first thing we need to settle, whether we are taking indirect holding right up to the target company level, or we stopping at the holding company, immediate holding company level itself. Supposing we take the view that we are computing the holding at the target company level, that's our, let's say, settled view. If we settle on this,
sir, in this case, do you think it needs disclosure if 100 crore and 5 crore?
no. So question is that I am holding 20% in the holding company.
Yes.
The holding company,
capital of 100 crores,
which could be having whatever
yes.
capital. My holding company is 20%, and the holding company is holding in target company is also 20%.
Yes.
So I am actually, through indirect rule, I am holding only 4%,
Yes.
which is insignificant.
Yes.
Therefore, no matter what is the capital of the holding company, there is no need for me to declare.
Yeah, but then sir, now if we extend this example, if A is holding stocks in company X also, and that company X holds the stocks in target company.
Correct. Now let's say, for example, there's another company here.
Yes.
And this company also holds, so I am holding 4% in target company through,
Yes.
let's say company Y.
Yes.
Then through company X, which is holding another 20%. Here also I hold 20% in company X.
Yes.
So what is my total? And let's say I directly hold shares of 4% in target company.
Yes.
Think of this scenario. A is directly holding 4% in target company. A is holding shares in target company through company X, and A is holding shares in target company through company Y. Do we have to aggregate all the three? Answer is very surely yes, because the entire holding of the natural person coming directly, indirectly, through whatever channels, गली घूम के आ रहा है तो भी इसको जोड़ना है.
Sir, if I change these two, if A holds 2% in X and X holds 75% in target.
Right. So once again, if we using the multiplier rule, 75% of 2 and 2 of 75% both lead to same thing.
No, point is that A is holding only 2% in X, but still it needs to be counted when we add up, right? Because
Correct.
in your initial discussion, you were referring to that if
the holding is less than 10,
then we
that's
don't
it.
need to drill down. But
But
I think we need to drill down.
We need to drill down by counting together the holdings of the individual. If the individual is holding 2% and 2%, that's it.
Yes.
And then company X is holding even 100% in the target company, there is no need to consider individual A at all. So for the individual who through various lanes and by lanes is coming to target company and his collected holding becomes more than 10, the rule of computation is that if you are using multiplier right up to the target company level, then the computation makes mathematical sense. Where mathematically, if I am holding 2% of 75% or 75% of 2%, the computation is still the same.
Sir.
But beauty with multiplier is that 75 of 2 or 2 of 75 both lead to same result. And we add up all this together to see what's the collected holding of the individual. It works out to more than 10. Very clearly the person is a significant beneficial owner.
Now, sir, if we take another example, this target company, we make company, let's say company M, and we work out here that it is not the target company. Now, target company is something
A company
else.
below, okay,
Yes, below,
right.
yes.
Okay, this is company M.
Company M, where we
Right.
concluded that A is holding 12%.
Fair enough.
Right? Now, the target company is coming here,
Right.
where he holds, let's say,
Company M holds.
company
Okay.
M holds, let's say, 20%.
Fair enough.
And
So if the,
A holds in that target company, let's say 8%.
so now we are doing determination at this company level.
Yes, yes.
So once
when
again,
we reach here, we have to come through that.
absolutely, through whichever lane, पतली पतली गली के थ्रू घूम के आपको ultimately we reach up to target company level.
We need to take that multiplier.
Ultimately we take multiplier all through. In case of direct holding, we take direct holdings straight away and aggregate all of them to see what's the sum total of the holdings of the individual at the company for which we are doing determination.
So is it sufficient to get one SBO in a
So-
company? Is it sufficient?
No. Every SBO has to, so let's put it this way. Question is, can there be only one SBO in a company? Surely not, because a company can have, since the benchmark is only 10, by definition the company can have 10 SBOs. The company cannot have 11 because 10 is anyway the threshold. So does the company have to have only one SBO? Surely not. The company can have as many SBOs as required. The onus is on the SBOs. So SBOs who do their own computation and find their holding is more than 10% will come forward and do a self declaration. If none of the SBOs come forward, there is no SBO at all, and the company is not able to use those provisions I just talked about where the company can nail them down through the NCLT, in that case the garland of SBO is in the neck of the SMO, right? So the SMO becomes the SBO in that. Now does the SMO have to hold shares in the company? Surely not, because he is the person who is driving the car by way of management rights.
And in Indian context, so far as our act is concerned, we have defined that a managing director by default is the person who is strategically taking decisions.
No,
So if a company
if the
has
company-
an MD, he will be taken as
No questions asked. If the company has an MD, no questions asked. The MD.
Therefore, in case of ITC, Mr. Puri would be taken.
No.
Or Mr.
Since we are recording this, we have to rule out the answer to this. And we are also the secretarial audits for ITC, so I will not comment on that as of now. Anyways, so as to who is the SMO for a particular company, will not get into that. But yes, by rule, if there is no SBO and the company let's generalize it. The company has an MD.
Because if the act defines who is the person who can take a strategic decision or who is deemed to have taken a strategic decision,
No brainer.
then MD by default becomes SMO.
I completely
In case of the companies like this, like in SDFC or SDFC Life or something.
Completely, I completely
But if we
agree.
know, the world knows that there is a chairman who controls the MD.
But he's the shadow owner. He's not the owner. He's not there on the
So
surface.
in that case, I mean, just for the purpose of academic interest,
Yeah,
these kind of
yeah.
situations.
And those situations are fairly common. It's a fairly common situation, and that's why I mentioned if the company has a managing director, by default the managing director is SMO. If the company has a CEO, we are saying he's chief executive officer, so he becomes SMO. The company has neither, but the company has a whole-time director, that means by default is SMO. The company has neither of these, but the company has a president, then he is the SMO. As I mentioned, there are lots of cases where the company has none of these. I think many of you in the room also, you're looking after 70-80 companies, each one of you, right? Each one of you are looking after 70-80 companies at the least. So I think collectively in the room, you're probably looking after some 700 companies. And you'll find lots of these companies are companies where there is no executive officer at all. We probably do not debit anything by way of salaries, employee benefit expense.
Normally in wholly owned subsidiaries, which are
Not only, I mean, wholly owned subsidiary is a very simple case. There are plenty of so-called satellite companies which are neither wholly owned subsidiaries. They are not even significantly influenced companies. They are not associates either. Holdings are scattered. The company has no expense by way of employee benefit expense. Every year we debit conveyance charges and we have debit office rental, and we debit staff stationery expenses, but we don't have staff salary. I am not sure if the company doesn't have salary, why do we need an office at all? I don't know, but well, there are lots of such cases. So question is, if the company has no executive staff, then who would be the SMO? Holdings are scattered, no SBO comes up, so who is the SMO? If there is no other identifiable senior managing official, I don't think we have the liberty of saying that the company does not have an SBO at all, because then the non-executive board will become the senior managing official. Therefore, the non-executive directors will then be held responsible as the senior managing officials for the
Sir,
company.
all of them or only the chairman?
Why chairman? And the board doesn't have a chairman also. The board has not designated anybody called a chairman. These companies, there is no chairman as such.
Normally, when you monetize, you choose one of them.
But that is not chairman of the company, that's chairman of the meeting.
Right.
Chairman of the meeting and chairman of the company is not the same thing. The company has not designated anybody as chairman of the board. It's chairman of the meeting.
I'm only trying to rule out, sir.
I know
from
the
my
ch-
understanding.
the chairman, the minutes, we understand the board minutes are only minutized. Board meetings don't have to take place, the board meetings are minuted, and there we show Mr. So and so become chairman. One other meeting we say another person became the chairman. Well, that's all year end affair. All of the minutes are merely year end job, and probably 4 or 5 years at a go. So that's the situation, and well, there the executive directors owe the responsibility of being regarded as the senior managing official. Ojaji, I'm not sure whether I missed your question. The question was, if we agree that we are ultimately talking about ultimate beneficial ownership, then irrespective of how many layers the holdings are coming through, no matter how many layers they're coming through, we compute all the holdings together, add up the holdings. If it's working out to more than 10, then the declaration will be required.
So that means
So,
all those, say, in the indirect holdings, all those indirect holdings comes to 8%, and this direct holding, the shares are registered in his name, comes to say 4%. So it becomes 12.
correct.
So
Therefore,
all 12 will be
correct.
aggregated and declared.
Absolute. Direct plus indirect. And in any case, if the direct holding itself was more than 10, then there's no need to declare. Direct holding itself was more than 10. Indirect holdings don't matter because on the face of it, the person is anyway an SBO. It's not because of indirect holding that is becoming SBO. The person is an SBO by way of direct holding itself. Therefore, there is no need for the person to make a declaration. He's an SBO for sure. A person who is directly holding shares of more than 10%, are we saying the person is not an SBO? The person is sure an SBO. But there is no need for him to declare because that's anyway visible on the register of members.
Sir, will it make any difference if in this example X also holds in Y and ultimately M holds in Y?
X also holds in
X holds in Y.
X holds in Y, and
M also holds in Y.
so that's circular.
Yeah,
one.
that's circular.
So this is something which is very common seen, looping shareholdings or circular shareholdings. Ideally, in case of looping or circulating shareholdings, the looping capital which is circulating back should be eliminated. By consolidation should be eliminated. But in real practice, my example of direct looping shareholding is rare, but that's very unimaginative.
Yes.
People don't make it so unimaginatively as I did.
If it is indirect, it will be very difficult to eliminate.
So if it's complex looping shareholding, it would be impossible to detect because it's only when you do a macro level consolidation that it would be possible to eliminate.
You probably need an algorithm to work out.
Absolutely, and that's not possible because that's something. Let's avoid getting into that situation. We will take the capital as capital, whatever is the capital is the capital, and looking at the aggregate holdings. If you have got circular holdings, difficulty would be one in computation.
Yes.
Because you are computing at company X Y level, and in company Y you go to company M, which once again comes to company Y. So this actually comes. If it's visible that the company in which you are holding share is holding back shares in the very company through another instrumentality, in that case elimination becomes very easy.
Yeah, but if it is complicated, but still you need to work out.
I think you need to work out. I would agree that you need to work out. It's a complicated exercise, but you need to work it out. I would agree on that.
So that means that the mere holding of 10% itself will trigger the requirement of declaration. For example, if a person holds, say, 10% shares of ITC, and if ITC sets up a wholly owned subsidiary, so he becomes a significant SBO of that subsidiary.
So question is, if somebody is a natural person holding more than 10%,
No, if somebody is holding, say, 10% shares in
a listed company.
ITC Limited.
Let's generalize. Let's say a listed company. Somebody is holding more than 10% in a listed company.
And the company, after some time, the company sets up a wholly owned subsidiary.
Correct.
So he
Becomes an SBO of the wholly owned subsidiary also. Correct.
He has to make a declaration.
Absolutely. At each company level, if the person is, for example, holding more than 10% in a holding company, the holding company is holding more than whatever percent in the target company, the person has to make declaration at each level without doubt. The person is an SBO for each of the company. If the person is an SBO for each of the companies, he has to declare it to each of the company. But the law should have actually enabled the company to seek the information from the holding company itself. For example, target company knows the holding company knows its own holding company, that company knows its own natural persons. So it should have been possible for the information to travel through these layers instead of the company trying to probe the natural person sitting behind several layers. Should have been possible to get it from the immediate holding company. However, the law doesn't say that the company, the obligation is on the holding company. The law says the obligation is the natural person. So irrespective of how many layers behind is the natural person sitting, the natural person will still be required to declare at each layer wherever his holding is more than 10%.
So,
Correct.
the very holding 10% itself will trigger a requirement of
Absolutely.
declaration.
Absolutely.
In spite of not having any
Direct interest.
interest or
Correct.
something.
Correct. So when we just took this example, in case of let's say a listed company, I am holding more than 10% shares in a listed company. The listed company forms let's say a WS, wholly owned subsidiary. So since I am holding more than 10% in the holding company, I automatically hold more than 10% in the subsidiary also, and I am therefore required to declare myself as SBO of the wholly owned subsidiary as well. In other words, saying that I have declared myself to the holding company will not absolve me of the requirement of declaring myself as SBO in the subsidiary.
So what will be the scenario in case the entity holding is a fund house?
That's
Specifically
okay.
a fund
Correct.
house.
So that's a very important point that you're touching, and let me just come quickly to that. What are the carve-outs in detection of SBOs? What are the carve-outs? So the carve-outs are non-applicability. In what situations we don't have to travel behind the particular owner? Just because there is a listed company holding shares in my company does not mean I will not trace the SBOs in the listed company. For example, in my company the shares are held by listed company, I will still have to trace the beneficial owners in the listed company. But in certain situations we don't need to travel behind a particular shareholder at all, and those cases are the rules are not made applicable to holding of shares in companies in case of pooled investment vehicles such as meaning what? This list is illustrative. Pooled investment vehicles such as what? Mutual funds, alternative investment funds, real estate investment trust, infrastructure investment trust regulated under SEBI Act. So there are 4 vehicles named there. I think very easy would be to first rule out REITs. Real estate investment trusts hold, what do they hold? They hold real estate. Infrastructure investment trusts hold real infrastructure projects. They don't hold shares in companies. So that's anyway ruled out. Mutual funds basically hold diversified holdings. They are also ruled out. Here is the exception or exemption given to alternative investment funds, AIFs. An alternative investment fund may basically hold shares in group companies only. In fact, in many business houses there are AIFs which are holding group shares. Now the rules say that we don't have to trace the holdings behind the AIF. If you got, let's say my company shares are held by AIF, I don't need to see who are the persons holding shares in the AIF. But that is a strange exception, because in that case if let's say the entire stock of my company is held by an AIF, I will not have an SBO in my company at all. So in that case, once again we'll have to fall back on the SMO. So natural persons who are coming via the alternative investment funds directly, in other words, the trace will stop. The trail will stop at the AIF. It will not go beyond that. So in case and the word is such as meaning this is an illustrative list. For example, if there is another pooled investment vehicle which is not an AIF, let's say think of a foreign fund, a fund outside India. If money is coming into the country through a fund in, let's say, once again Cayman Islands, and which is not regulated by SEBI but still a pooled investment vehicle, so we'll have to stop the trail at the fund and will not go behind the fund, which means practically it's still possible for natural persons to sit behind a fund and say that, for the company to take a defense that there's no need for the company to travel behind the fund. That's one of the loopholes, and I think a big loophole left by the lawmaker. But anyway, let's see how it actually operates.
We don't need any declaration from, or we can ask from.
Once again, if in the behind the fund there are natural persons and they know that they are the real beneficiaries. By casting the onus on the SBO himself, the law has done its bit. The obligation is on the natural person. If the natural person is behind the fund, he is controlling the fund, for example, and he doesn't make a declaration, in that case he becomes liable to be prosecuted. The obligation is on the person. If the person is clearly controlling the company, sitting behind the facade of the fund, and he does not declare himself, he is making himself liable for prosecution.
AIFs are made to invest in group companies.
Maybe in group company there are concentration limits.
SEBI approved and stuff like
No, there SEBI doesn't see where are you actually investing. There are sectoral limits for mutual fund, but there is no sectoral limit for alternative investment funds. AIFs can invest
so
in.
misuse to invest in group companies.
One
I
can
can be
s-
one of the investing AIF and I can direct the AIF to invest in my company only and I take this center.
One can say it's a misuse, but good part is that there are several AIFs which are actually making investments in group companies.
And then sir, in that case, why should, I mean, if there are PMSs also, they are not.
PMS,
not
the holding is still in the name of the actual
Right.
individual. Manager is simply managing. The manager is not, there's no pooling of, in PMS there's no pool, it's not a pooled investment vehicle.
Yes, yes.
Pooling happens in case of AIF or CIS or mutual funds. A PMS is not a pooled vehicle at all, there's no pooling. So,
In case they say that the foreign fund houses, they do not have any specific beneficial owner, or if they give a declaration or something like that, we don't need to drill down further.
so let's first say that it's not, obligation is not on me to actually conduct a investigative trail. I don't have to kind of drill down, and I don't have to sit like a investigating house to investigate the ownership of funds. The obligation is on the SBO. So let's probably settle down on saying the SBO thinks that he want to declare, let him declare. Does not want to declare, he is doing a breach of law, it's up to him. He will face the consequences of breach of law. On the contrary, if you have information that there is a person behind the fund and the person does not declare, in that case you should take the next step and ask them to declare themselves. If still don't do, in that case use the NCLT window to force them to do. The company has information, the company should take the next steps and trace. If the company has no information, then there is nothing for the company to do.
Sir, what in case of a natural person who has passed away and is staying?
Very good question. Good question. And I mean, do you have such examples? These examples that the question is about. Do you have other examples also? For example, estate is one example. If there's a, you have such examples also. You would like to ask? My question is, would you like to discuss real life cases like Ajayji just asked about as estate of a natural person? Do you have any other examples?
So what is the question?
You have? Okay, right. So, question is, if the shares in a company to the extent of let's say more than 10% are held by a dead person's estatee, the estate has not passed, the estate is still under administrator is holding more than 10%. By the way, I am sure you understand what am I talking about. There is a huge amount of shares held in the name of a dead person, and who the actual beneficiary of the will is yet to be settled by Supreme Court. I think 14 years are over, and I am sure another 14 years will not know who the actual beneficiary of the will is. So currently the shares are managed by a so-called administrative committee, actually APL committee, so to say, administrator pendentality committee. Right, but there might be other cases also where the estate has not been transferred still. The shares are in the name of a dead person. Is the dead person a natural person?
No.
So I don't think that's, once again, it's a counterintuitive to say a dead person can't be a natural person. Administrator is a natural person. Administrator is holding natural person, but administrator is not a beneficial owner. Administrator is purely an administrator. The stress on section 90 is beneficial owner, and the real beneficiary is not yet known. So while the beneficial owner is not known, but very truly the administrator is acting as a trustee for the unknown beneficiary is yet to be known. If the beneficiary was known, there was no need for administrator. The beneficiary is not known, therefore the trustee is acting in trust for the beneficiaries. So in case of shares held in trust does not mean there has to be, I mean, X by G trust. It doesn't have to have a no. Trust is every situation where I hold a property in trust for somebody else. That's a case of a trust. So in case of shares held in trust, identification of natural persons will include any of these. It could be the beneficial owner, it could be the settler, it could be the trustee, or the person exercising effective control. So here if we take the administrator is the person who is effectively exercising control. Whatever is the holding of the estate, the administrator is the one who is exercising all beneficial interests, including voting rights. Therefore, the administrator clearly becomes, and the administrator is a natural person. The administrator becomes a natural person exercising beneficial interest.
No, sir, if the administrator holds only 5%. I
But
mean,
that means the estate holds 5%.
Yeah,
Huh.
state holds 5%,
Right.
and another natural person who is part of that family only, or let's say
Who is still alive.
who is still alive, holds more than 5%.
Mhm.
Then what?
No.
We club them, and
So
they
the-
are otherwise always related and always disclose that they've together done everything.
So I am not sure who is the deceased and the living
Yeah.
person are acting together.
Have acted together.
Have acted
all their
together.
life, let's say.
Administrator is now not a part of the family, or is the administrator part of family?
I don't know, may or may not.
So if
be.
the administrator
We are
is
just
part-
discussing hypothetical
So
situation
hypothetically,
that
administrator is a part of the family, and the administrator has a truck or has a collusion with another living person who is also a member of the family, and the holding together becomes more than 10. We are clearly saying we should go and declare. Administrator is a court-appointed administrator who's got nothing to do with the family,
Yeah, then
and the holding is less than 10, but with the living person it becomes more than 10. There is no reason to declare.
If the holding company is a Section 8 company limited by guarantee.
Section 8 company holding shares.
Section, yes sir.
Acha. So now this is another very
Limited by guarantee.
limited by guarantee. Where did money? Acha. So we have all kinds of vehicles. Okay. Section 8. Is it necessary to identify significant beneficial owners in case of Section 8 companies as well? See, it's a fallacy to declare beneficial owner of a Section 8 company is a contradiction in terms. A Section 8 company cannot have a beneficial owner at all. It's a contradiction in terms. Section 8 company by statute, the objects are for a not-for-profit cause. The company cannot distribute dividends. The company cannot distribute assets on winding up. Therefore, there is no concept of SBO in case of Section 8 companies. However, somehow the fallacy is that law has not made an exception. So, Section 8 companies themselves have to identify their SBOs, which is actually a fallacy in my view. Now, Section 8 company might be holding shares in another company. So, question is, Section 8 company is holding shares in my company. For me, the the shareholder is Section 8 company. Who is the natural person behind the Section 8 company? I would argue that Section 8 company cannot have a natural person behind it, because that would be a complete contradiction. Beneficial ownership meaning what? Being entitled to the benefits of owning a share. How could somebody owning shares in a Section 8 assuming Section 8 company is a shareholding company with share capital? If it's a company with guarantee, then the question is even easier to answer. If the company is a company with guarantee, then there is no question of beneficial owner at all, because there is no capital. So there is no question of dividends or voting rights at all. Voting rights will be one per member. There cannot therefore be a situation of more than 10% at all in case of a Section 8 company. So my position would be Section 8 companies can't have, it would be a contradiction in terms to talk about SBOs in a Section 8 company anyway. There is no, same question comes for government company. If you have a government company, how do you identify shares are held by President of India? Shall we say the President of the country, the first person of India, is the SBO for government companies? Once again, it's a fallacy. President of India is not a natural person. President of India is an office.
So, therefore, to answer this question, if Section 8 company holds shares in a particular company, where a natural person also holds, let's say 9%, and Section 8 company holds 20%, and that person is one of the
Trustees or directors.
or member of that Section 8 company, and let's say there are only 10 members, so he becomes 10% in that. So, should we not club it?
So, if we are saying that, well, though it's a Section 8 company, but actually it's driven by some natural person.
Ultimately, because there are so many clubs which are in that way. I don't know clubs.
Clubs can't hold shares actually. So, but Section 8 companies which are part of, let's say, business, business houses, or they're part of companies in a group, those Section 8 companies actually also sometimes are used as instrumentality. They're used as instruments of promoting business interests. So assuming that Section 8 company holds shares in another company, and the Section 8 company is driven by a person who happens to be director of that company, and if we take a view that this director is the one who is actually calling the shots, he is the one who is actually controlling the Section 8 company. I mean, though in my view that would be contradiction, then we are challenging the very nature of a Section 8 company. A Section 8 company has to be run for what purpose the company is formed. Even if somebody controls, he can anyway use Section 8 company for whatever purpose the company was formed. So while we are actually contesting or contradicting the very purpose and nature of business.
So Section 8 companies will not have beneficial interest, therefore that should be excluded.
Absolutely. The Section 8 company cannot have any, because Section 8 companies are
Whatever
dedicated.
benefit they may derive from this company would be used for a specific purpose.
They can't
not
derive
for the
first.
beneficial
First of
purpose.
all, the shareholders of the company can't derive even 1 penny, because the company has to use whatever it earns for its objects only. It will never distribute any dividends or any assets on liquidation also. Therefore, a Section 8 company is like a permanent dedication to social cause. So no matter how many what shareholding do I have, I can't lay hands on that money ever. So there is no question of Section 8 company ever holding, somebody ever holding a beneficial interest in the Section 8 company. That's one point. And okay, so Pemi, any particular cases?
For deceased shareholding, as you were saying, as you said that it's the administrator or the executive.
We are coming by this, the person holding shares in trust. So they are either the trustee or the person effectively exercising control over the shares held by the trust. So in case of, let's say, administrator, the administrative body, the administrator is appointed by court or administrator appointed as per will of the individual, should be regarded as the natural person holding more than 10, if it's holding more than 10.
LLP will be treated.
LLP, good point.
That in many other countries, like
Huh?
this executors and administrators, they have been exempted. While you were discussing about only the beneficial ones, but here we have not been given such in case of deceased.
So I think the issue would be the person who is the estate is holding more than 10%. Do we completely disregard the holding of the estate, or we see the person who is actually administering the estate? Estate is consisting of a dead person. In case we are disregarding the holding of the estate altogether, then I think we should disregard it from the numerator also. From the company's capital itself we need to take it out. But then that 10% should be 10% after excluding the shares held by the estate. We are not doing that. So why would we exclude the holding of the estate altogether? And the estate is after all looked after by a natural person. He is working under, let's say, either the terms of the will or under instructions of the court, but he is a natural person for sure. So he is ultimately exercising effective control. If we take the view that the administrator is getting instructed by the court, then we can't regard the court as a natural person once again. There that the control of the administrator will have to be ignored. But I am not in favor of ignoring the holding of the estate completely. Right? LLP, very good question. Shares held by LLPs, where do you capture? Some people actually go on and said, see, we are applying a literal rule. The first Roman 1 of the definition says, Roman 1 says, where the member is a company. Roman 1, where the member is a company. What does the word company mean? Does the word company include foreign companies? Foreign companies. Are the foreign companies companies? Foreign companies are not companies. So the member is a foreign company. Shall we disregard the holdings in the foreign company altogether? Because if the law says company does not include body corporate. And therefore foreign companies are not companies, they are bodies corporate. Are we therefore saying that the natural persons holding shares through foreign companies will have to be disregarded? Now we are applying a literal rule here. That's not the intent or purport of section 90. Like I said earlier, the whole purpose of section 90 is to pervade through legal myths and try and nab the real person driving the company. So we should not be illusioned by artificialities. Therefore, going by literal interpretation that the word company is a company cannot include a foreign company, and therefore will disregard the whole persons holding shares through the foreign company, I don't think that would be a justifiable interpretation. Therefore, very often when we use a word in the law, we say the word will have its meaning from its context. If the context so admits, we can deviate from the definition of the law and use a wider interpretation. So here the word company should include a foreign company as well. particularly because section 90 anyway says through a person resident inside India or outside India. Second question, in case of LLPs, what will you do? We talked about company, partnership, firm and trust. We have not talked about LLPs. What is an LLP? LLP is after all a partnership. So in case of LLP is nothing but a limited liability partnership. So 10% interest in the LLP, if natural person has more than 10% interest in LLP, and once again drilling down till the target company level, if the interest works out to more than 10% anyway, then we'll capture the holdings through LLPs as well. Natural person, individual, there is no difference. Natural person and individual mean the same. Why? What is the, what's the idea of individual being different from natural person? Individual is natural person. What is an individual who is not a natural person? Natural person and individual mean the same thing.
So there were also certain issues with respect to who will be SMO of the reporting entity, which is a
Correct. A lot of people have actually raised this issue. When we talk about senior managing official, are we talking about senior managing official of the target company or senior managing official of the holding company? Like in case of a wholly owned subsidiary, let's say the wholly owned subsidiary does not have an executive director at all. Holding company has a managing director. So while identifying the SMO of the senior managing official of the subsidiary, do we look at the MD of the holding company or do we look at the SMO of the subsidiary? So
Or SBO of the holding company.
or SBO of the holding company. If there is an SBO of the holding company, then the SBO is anyway the SBO of the subsidiary also. If the holding company has a significant beneficial owner, then naturally, as Mr. Subramanian just said, it automatically becomes the SBO of the subsidiary also. No questions asked. In that case, we don't need to track the SMO at all. Assuming the holding company does not have an SBO, there is no SBO. So we are actually treating the SMO as the SBO of the holding company. Now the subsidiary also doesn't have an SBO. Obviously, subsidiary also does not have an SBO. So who will be the SMO of the subsidiary? SMO of the holding company or SMO of the subsidiary itself? Subsidiary has a precedent. So while there is a lot of confusion on that, but I don't have even a shade of doubt. By presumption, every company is autonomous by itself. If the company is driven by its own executive team, if the company has an executive team, the company has a president, the company has a manager, the company has a managing director, there is absolutely no reason to regard the managing director of the holding company as the SMO of the subsidiary company. If the subsidiary itself has a management team, then very clearly the head of the management of the subsidiary, because the issue once again is who is driving this vehicle. If the subsidiary is the one for which we are doing determination, whoever is taking strategic decisions for the subsidiary is the one who is SMO of the subsidiary. It would be a counterintuitive argument to go one step up and say who is driving the holding company and therefore that's the one driving the subsidiary. Then we are arguing that the subsidiary is not run by its own board or its own team, it's run by the holding company's team, which is actually, that could be correct, but on presumption we will not take that as the case.
So sir, where in a company we are able to identify an SBO, even one.
Correct.
Then in that case, this
SMO identification is not required. So quickly summarizing, first we will say the computation of the percentages. I think let's put it this way. First, if the person is directly holding 10% shares in the company itself, then there is no need for him to declare. That's the rule, make it very clear. Rightly or wrongly, the rules say if you are holding shares in the company directly and the holding is more than 10%, there is no need for you to take the next step of declaring, because that's anyway transparent from the rule, from the register of members itself. Secondly, in terms of indirect holdings, how do we compute the percentages? Logically, going by the word ultimate beneficial owner in the beginning lines of rule 2(1)(e), it seems that the indirect holding will have to be computed right up to the target company level. using a multiplier approach. Multiplier approach is most scientific mathematical approach, and it leads to no conflict in terms of adding together holdings coming through various lanes and bylanes. If the holdings in target company comes through various lanes and bylanes, we can still use the multiplier approach and finally lump together or add together the holding of the individual to see whether it's more than 10%. So recommendably, the multiplier rule should be working right till the target company's level, and this is still consistent with the language of Roman 1, 2 and 4, because in the beginning para itself the language is ultimate beneficial ownership. Right? Taking that as the kind of overarching word of the entire regulation, it seems that the multiplier rule will be applicable right till the right till the target company level. That's the second important conclusion. Third important conclusion is that in one company there can be more than one SBO, and therefore if there is more than one SBO, all of them should come forward, and one person can be SBO of more than one company. That's also true. A single person can be SBO of more than one company, in which case at every level the person will have to declare himself. Next point, if there are holding together, whether the shares are held together or not is to be determined by the relevant holder in the context of the company. We are not saying they are saath for everything,
Yes.
but they can be saath for this company, whereas they may not be saath for other ventures or other business of theirs. As long as they are holding shares together for this company, their holding should be actually counted together. The onus for which is on the person himself. The person himself has to ask this question in his heart, whether they are acting together. If yes, let them go and make the declaration. If not, the onus is on them, because they are then contending that they are not acting together as far as the control of this company is concerned. Next point, if the company has an SBO, either based on register of members or through indirect holdings, there is no need for us to go and catch the SMO.
Even in case of wholly owned subsidiary.
If the company has an SBO directly, indirectly, in combination through register of members, either way, there is no need for us to go and capture the SMO at all. Next point, while a company can have more than one SBO, international regulations can say that a company will only have one SMO. SBO can be more than one. SMO is the person who is taking strategic decisions, so it can only be one person, or it can be a plural body like the board of directors. If there is no SMO at all, nothing else is identified, we will say the non-executive board becomes the SMO, therefore it can be a plural body, but we can't have more than one SMO in a particular company.